There are lots of ways that copyright actually impacts you. But even more than that, as a lawyer, almost every single agreement that you will see today has copyright implications. So what can't be protected by copyright? Well, ideas. And why? Why can't ideas be protected? Because there are only a handful of ideas in the whole world. When you invest time, energy, and money in creating content and then registering it, people don't treat it as a valuable asset.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker for today, Francine Ward. A 1989 Georgetown University Law Center graduate, Francine D. Ward has been practicing law since January 14th, 1991. She is an intellectual property and estate planning attorney admitted to practice in California, New York, and the District of Columbia. In addition, Ward is a respected professional known for helping clients resolve problems and keeping their goals top of mind. Francine's IP practice specifically focuses on helping clients protect their A, valuable creative content through copyright protection, B, distinctive designs, logos, words, phrases, and other source identifiers through trademark protection, and C, books and other licensed work through carefully negotiated publishing and licensing agreements. The webinar presentation that you're about to watch will be approximately 1 hour, and Francine will be taking questions from the audience once that presentation is complete, time permitting. So if you have questions that you'd like us to get to at the end of the presentation, you can submit those anytime by clicking the Q&A button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here is Francine to discuss Copyright Demystified for Non-IP Lawyers, what every lawyer should know to keep clients safe.
Thank you so much, Nina. Good morning, good afternoon, wherever you may be today, and welcome. First, as all lawyers that are doing a presentation, let me first say anything I share today, or rather nothing that I share today, should be construed as legal advice. It's really just for your benefit, information for educational purposes only. And any lawyer that's here already understands that. So today the agenda will be like this. I'm going to share just why I think it's important for non-copyright lawyers to understand anything related to copyright. We're going to take a look at some copyright basics, protection of copyright. We're going to take a look at, in particular, fair use, and then a couple of landmines that I realize that people often get hung up on when it comes to copyright matters or any intellectual property law matters. So the first thing is, why do copyright matters matter to you, or why should they, especially if you're a non-IP lawyer? Well, number one, just about every single person today is on social media. And so oftentimes people are creating content on social media, whether it's their banner, whether they're using photographs that belong to someone else potentially, whether they have taken portions of a blog or an article they found on the internet and incorporated into their own materials. There are lots of ways that copyright actually impacts you. But even more than that, as a lawyer, almost every single agreement that you will see today has copyright implications. So that's really one of the reasons, or among the reasons, I think it's so important. So let's take a look at what we're going to talk about regarding the basics. What does a copyright protect? What does a copyright not protect? Who owns it? And how long do copyrights last? So first, the U.S. Code tells us what the subject matter of a copyright is. And just in general ways of thinking about it, it's any original work of authorship or art that's reduced to a tangible format. The legal protection is afforded to that work. And the operative words here for you to really think about as we go through this entire session are original works and tangible formats. Original and tangible. That's going to be the key to copyright protection. So some of the things that copyright protects literary works like photographs, like articles, like books, like software. And then it also protects uh, pantomimes, choreographed works. It protects musical compositions and sound recordings. And the distinction between sound recordings and musical compositions, in case you're not familiar, with a musical composition, think in terms of sheet music. You've got the lyrics and the melody, and then the sound recording is the final product. It could be a record album, it could be a download, it could be an MP3, it could be um, a cassette. It could be something, but it's the final recording of that song. Website content is protected by copyright. Again, books are protected, software, and also if a client comes to me and they say, okay, Francine, I'd like to protect my software, we can, but I would send them to a patent attorney. So software can be protected by both patent and by copyright. Cartoon characters can be protected by copyright. A number of items, articles. Let's say my PowerPoint presentation is protected by copyright. Lots of things, anything that's original content reduced to a tangible format. And what does it really mean when you think of tangible format? Well, it's anything that is or that can be perceived, something that can be perceived with your senses, or even if you use a device to perceive it. So, for example, if you have a book, and let me just step this back one moment. If you have a book, you can either read that book as a hard copy, a piece of printed material, or you can read that book as on your device through an ebook reader. So either way, as long as you can perceive it, it can be protected as long as it's an original piece of content. Sculptures can be protected by copyright. Architectural designs can be protected by copyright. And in fact, architectural design sometimes can also be protected by trademark, but that's a whole nother issue. Jewelry can be protected. Again, the key here is original and reduced to a fixed format. So what can't be protected by copyright? Well, ideas. And why can't ideas be protected? Because there are only a handful of ideas in the whole world. How do you know that? Think of how many movies, for example, you've seen that speak to boy meets girl and lives happily ever after. Or how many movies you've seen that say boy meets girl and they don't live happily ever after. Or it could be boy meets boy or girl meets girl and they live happily ever after. The bottom line is it's still the same basic idea, but it's the expression of the idea that gets protected by copyright. Processes, systems, methods, they cannot be protected by copyright. If indeed a process rises to the level where it deserves protection, it's going to be protected by a patent. Book titles can't be protected by copyright. A few years ago, I had a client come to me, and I will tell you, they wanted to stand me down. They said, Francine, I want to protect my book title. I said, book titles can't be protected by copyright. They said, oh, yes, they can. I know they can because I had a friend that did it. I said, book titles can never be protected by copyright. If a book title is to be protected, it happens through a trademark. And then there are certain things that must occur in order for that to happen. They kept insisting that the book title could be protected. And as I continued to listen, I realized they weren't necessarily talking about the title, but they were thinking about the entire book. So a book, as long as it's original, can be protected, but the title itself cannot be protected by copyright. Facts cannot be protected. Anything that's in the public domain. And what are some of the things that go into the public domain? Well, for example, any works that are created by federal employees within the scope of their employment, 9/10 out of 10, those things are not going to be protected by copyright. Anything that is not original goes into the public domain and it won't be protected. Anything that's not reduced to a tangible format. So let's suppose you have a client who comes to you, and again, you're not an IP lawyer and they don't really understand the IP process. But let's say they come to you and they say, okay, I gave a talk, and no, it wasn't recorded. No, I didn't have a script. Somebody stole that idea for that talk. That's what this client tells you. Well, there's no protection there. That's immediately in the public domain unless the expression has been reduced to a tangible format through a video, through a script, some kind of writing. Otherwise, it's in the public domain. What else goes into the public domain is, let's suppose you have a client who had something that was, let's say they created it prior to March 1st, 1989. And that's around the time when we actually entered into a relationship with the Berne Convention, which is a copyright treaty, an international copyright treaty. And at that time, a lot of things actually changed. For example, registration of copyright was not required, but also what was required before that time was you had to have copyright notice. Had to be some kind of copyright notice. Now, if the work is created since that time, notice is not required. So if they created it prior to March 1st, 1998, they created it prior to that time, and they did not have notice, then that work initially went into the public domain. What else is not protected by copyright? Well, fashions are not protected. Although the Supreme Court did hold in, and I provided that case. There are a few cases after every topic for your information. You can take a look at some of them. But there was a case that the Supreme Court held. It's called the Star Athletica case. In that case, while fashions are still not protected, the Supreme Court came up with something called the separability test. And so if you have a fashion, which a fashion is a piece of functional art, or it's a piece of functional art. So the fashion itself is not protected. But let's say you have something creative, something original and creative that's on the piece of fashion, the article of fashion that can be separated, then that can be protected, but the article of clothing itself cannot be. Slogans are not protected by copyright. If a slogan or a phrase is to be protected at all, it's going to be through trademark. Again, here are some case resources that you might want to take a look at some point, and they give you a general idea of some of the things that are protected and not. So, for example, in Baker v. Selden, that's where someone actually had a process for bookkeeping, and they included it in a book. And they assumed, because they wrote about it in the book, that the process itself was protected. And the Supreme Court said, no, it's not. The book might be protected, but that process in the book is not. So here are a few cases that you might want to take a look at. So ownership of copyright and transfer. So the general rule of copyright law is the person who creates the work, the creative work of art or authorship, they are the ones that own the copyright. Now, there are some exceptions, and one exception is if you actually have entered into an agreement whereby you transfer the rights. The other exception is work for hire. So work for hires show up in two different ways. The first way a work for hire shows up is if you have an employer-employee relationship. So let's suppose you're an employer And let's suppose as an employer, you hire an employee. And we're not talking about an independent contractor. We're talking about an employee. You pay their fee, you pay their, you include all the taxes or Social Security, whatever is included when you have an employee. Let's say that employee is hired to create some amazing marketing materials for you. They create video of your business. They create some really cool marketing photographs of you. Let's say in that press packet, they also come up with a new branding, a new logo, a whole branding section. Everything's new, fresh, and they create it for you, but they create it for you as an employee. Well, let's say you terminate their relationship, or let's say even they leave. Let's say they just decide they want to go and they want to have a better or a different experience. Maybe they who knows, but they leave. They leave and they take those beautiful marketing materials that they created for you along with them, included in their press packet so they can share with any potential new employer. I will tell you that is going to be copyright infringement unless there was an agreement in place that said they had the right to do that. Otherwise, they did not. An employee, if they create work within the scope of their employment, it's the employer that owns the work, not the employee. The other way that work for hire shows up, which I would imagine many of you at some time or another have probably bumped into this, and you're going to be a little shocked when you hear this part. So let's suppose you hire someone to design your website. Or let's say you hire someone to take some fabulous new photographs for your website. Or let's say you are getting married and you hire a videographer or a photographer to take, a video, to create really beautiful photographs of your wedding. You believe, rightly so, that, okay, you paid for those items, therefore you own the rights to them. The answer is no way. Now, you may have physical possession, let's say the video. You own that video itself, but you do not own the underlying rights to the video. With independent contractors, it gets to be so tricky. And that's why having a really clearly defined work for hire agreement is essential before you start having someone do work for you, before you commission them to do the work. Why? Because after the fact, if you wait until afterward to then go back and say, I'd really love to have you sign this agreement, or I'd really like to have you sign this transfer copyright agreement, because that's what it would be after the fact. And let's say they say no way. They will do it only if you pay them an awful lot of extra money. Well, that's why it's so important to make sure those agreements are signed in advance. And here's some sample language that I sometimes use in creating my work for hire agreements. And I always include an assignment provision. Now, you are free to use this, and you can customize it in whatever way you so choose. But essentially, it's saying, all right, title to an interest in the work product. So that could be whatever the work product might be, photographs, a website, whatever it is, but not limited to a number of things. I like to throw everything in the mix if I can, especially everything they might be creating for me. So if they're creating a marketing package, then I might want the templates, the notes, I might want reports, I might want the raw material, I might want every single thing I could possibly get. That would be included in what I define, or how I would define IP. I would also include a segment here that states, in the event, to the extent that title to such work does not vest in me, if I'm the one that's hiring them, by operation of law. And sometimes that happens. It depends on the state where you are. It depends on the law that's in effect at the time. To the extent that that title does not vest in me, then I include an assignment provision. So again, this is something you're free to use. You can modify it in whatever works for you. But it's really important if you are creating work for hire agreement, you want to just add that extra assignment provision, because very often work for hire agreements fail. And if yours fails, you don't want to lose the right to the content that you have actually paid for and that you want. So you want to make sure that contract is pretty solid. And as lawyers, you already know that anyway. So another way of transferring an article of art or authorship is if it's jointly owned. So joint works of art show up in three ways. Number one, if there are more than one. So if there are at least two or more authors, if there's an intention that they will enter into a joint relationship, and if the parts that they're creating are interdependent, which means they really can't be separated logically. So, for example, let's say there's an author. Let's say two of your clients are creating, let's say, a book. And the book has images, and those images are integral. They are integral to the success of that book. Therefore, those parts are interrelated. They have to be there. So you've got two authors, you've got parts, component parts that need to be together, and they've intended to enter into a joint relationship. That's when a joint relationship shows up. I'll tell you quite honestly, I often discourage clients from entering into joint relationships because, number one, inevitably, there are problems on the back end. I mean, sometimes it has to happen. You know, if they're creating music, sometimes it definitely needs to happen. But if that happens, I'm going to make sure that I'm dotting every I, crossing every T. I'm making sure that contract, depending upon which client I'm representing, is really strong. Because if not, they can enter into a relationship and find after the fact that it's not what they intended. So I've tried to include some practice notes after each one of my segments. So here, with regard to joint relationships, I think it's important that you and your clients understand what a copyright joint relationship actually means. And in essence, it means that each party has an undivided interest in that work. An undivided interest, which means that one party can do something. They can, for example, license the work and not tell the other party, and they're free to do it. Now, they would need to account for whatever payments have been received, but they can go and create derivative works. They can do anything they want because they have an undivided interest in that work. If you have a client that really does not want that to happen, they need to make sure that there's no joint relationship that's being entered into. Another thing to note about joint relationships is that the contributions do not have to be equal. So let's suppose one client contributes, let's say 10% of the work, and the other client contributes 90%. If they come to an agreement that this is going to be a joint relationship, again, intention is critical. So if they come to that agreement, it doesn't matter how much one has given and the other hasn't. And as a result, unless there's something in writing that actually says when it comes to the payout, the party that gave 10% will only get 10% of the payout and the other gets 90. Unless that's clearly defined in writing, their their portion will be divided equally. So that's something also to be aware of, because oftentimes people enter into joint relationships where they've collaborated and they assume it's going to be joint, but they think the person who's only contributing a little bit is only going to get a little bit. But unless that's in writing, it's not going to be the case. If the intention is not to create a joint relationship, then they need to be crystal clear that their behavior doesn't demonstrate something else. And that often happens. That even happens with miscalculations when there's an independent contract relationship and an employee. Someone may assume that it's not going to be an employee relationship, and yet their behavior speaks differently. So your client needs to, or you need to make sure that your client is crystal clear that if they don't want it to be a joint relationship, their behavior has to not contradict that. Again, contradictions of mere ideas, refinements, or directions generally do not result in a joint relationship. I say generally because if you agree that it's going to be a joint relationship, then it will be. So if one party only contributes the idea, and again, keeping in mind, ideas are not protected by copyright. But if in this relationship, in a written document, the parties agree that without that idea, there would not have been a final product, and that they want to enter into a joint relationship, then it will be. Then it will be considered part of the joint process. So again, making sure everything is in writing, I think that's the key. Making sure everything's in writing and exactly what your client or what you want is stated. So another way that works of art or authorship are transferred are through assignments and licenses. So an easy way just to talk about an assignment is when you give up everything. You literally turn over all of your rights to someone else. So let's say you have a book. Let's say you've written a book. Oh, better still, let's say you've created a program. Let's say you've got videos in the program. It's a big coaching program, let's say. So you've got videos, you've got templates, you've got scripts, you've got all kinds of really cool things in this package, this coaching package. If you assign the rights to that package, you are literally getting a fee, whatever that fee is, and you're turning the entire package over to whomever is purchasing the assignment. They get everything. You have no more rights. They have everything. On the other hand, let's say you decide that you only want to license the work. And a license is where you retain the rights, but you allow someone else to use the work for a fee. Now, there are two different types of licenses, and this is just generally speaking. This is really a copyright overview. A non-exclusive, well, first, the exclusive license is where you give up the right to one person to use that work. So that big program, that big coaching program that you or your client created, if they're licensing that, and if they're giving up an exclusive license, that means they're giving it to only one person. Now, it could be one person or one entity, let's say just in the United States. It could be one person, one entity, let's say in China. But it's one person in maybe a territory or period. It could be just one person who has the right to use that license, that exclusive license, wherever they choose to use it. Sometimes with an exclusive license, let's say the copyright owner for themselves, they might want to still be able to use some of that content, even though they've granted an exclusive license to someone else. We call that a carve out. So the copyright owner has carved out a piece of that exclusive license, retained it for themselves, but only that other entity is allowed to use it. Then on the other hand, we've got a non-exclusive license. And a non-exclusive license is where the copyright owner might grant the right to a number of people or entities to use that coaching program. Let's say they decide that they want to give it to 10 different people or more. They're free to do that. And in the agreement with each of those parties, they understand that the license they've been granted is a non-exclusive license and that others also may be using it. So those are also ways that you can transfer copyrights. So here is something that is very tricky. And the Copyright Act has afforded this right to copyright owners. There are two sections in the Copyright Act. There's Section 304 and Section 203. And essentially, they provide, with exceptions, a copyright owner or their statutory heirs the right to terminate an agreement that they provided to an entity 35 years after that agreement has been entered into. They can terminate that relationship and recapture the rights to their work. Whoa. I mean, that's been done successfully and in some cases not, because there are certain conditions that have to be met. But there have been many cases where, for example, let's say artists, musicians in particular, we're seeing it happen, where a musician, way back in the day when they gave up the rights, now they gave up the rights for a fee, of course, but over the years they've discovered that that piece of work, maybe it's a piece of music, whatever it is, has really become very, very successful. Maybe a piece of artwork has become really, really successful because of the person that actually made it successful over the 35 years. But nonetheless, as a result, the original copyright owner has the right, under certain circumstances, to go and terminate that relationship and recapture their rights. So how long does a copyright last? Well, today, let's say if you have a client that creates a work of art or authorship since 1978, if they create that work, let's say just the last year or 10 years ago, it's going to be their lifetime plus 70 years. So when they die, it's going to be 70 more years. And let's suppose there are multiple authors. Let's say they've entered into a joint relationship. It's when the last surviving author passes away. So it's lifetime plus 70. Now, if it's a work for hire, if it's a piece of artwork or a piece of authorship that was created anonymously or pseudonymously, it's going to be 95 years from publication of that piece of work or 120 years from creation. Anything created prior to 1978 is a little bit more tricky, and it really will depend on whether it's still entitled to some renewal. So that's a whole other story, but anything created in more recent times, it's going to be lifetime plus 70. Here is a document I honestly think you should put on your desktop. This is called the Compendium of Copyright Office Practices. Now, this is really quite wonderful. This document is very lengthy. It's over 1,000 pages. And this is what the Copyright Office uses when an application comes in. I mean, this is really quite amazing. And I would encourage you to take a look at it. It's really wonderful because it breaks up everything by section. For example, There's a section on transfer of rights. There's a section on registration of visual materials. There's a section on registration of literary works. I mean, it breaks it up. And the other cool thing is it actually has lots of examples, lots of little anecdotes, lots of examples that help you better understand. So this is something you can find on the Copyright Office website, US, it's copyright.gov, copyright.gov, and on the home page, on the right-hand side, you'll be able to find the compendium. You can also Google for the compendium. Once you get these documents, I don't think you've received my materials yet, but when you do, you'll be able to just click on the link and it'll take you right there. So that's the compendium of Copyright Office practices. Again, here are some cases that might be of use, helping you understand what ownership is all about. And again, that first one is really important because it speaks to works for hire. It's interesting. When I was in law school, I went to Georgetown, and right across the street was the Community for Creative Nonviolence. And when this was going up, when that design, that sculpture was going up, we were watching it happen. Literally, it was right across the street from my school. So that was pretty interesting. Okay, so how is a copyright protected? Well, there are a couple of things. Number one, I think most important, and many people they just blow this piece, which to me, it doesn't make sense when you invest time, energy, and money in creating content and then registering it. People don't treat it as a valuable asset. And it is. It's a valuable asset, and it's important that you treat it as such. The other thing is reviewing contracts carefully, because again, more often than not, contracts today have not only IP in general implications, but copyright implications. And sometimes it could be really tricky. It might be, it could be an employment agreement, and there is some notation in there that basically says, well, it could be a work for hire provision, and the person doesn't understand it, and yet they go ahead and sign up on that agreement. So really understanding the importance of reviewing those contracts before they are signed. And I believe everybody here is a lawyer, so you already know to tell your clients that, and you yourself know. So making sure contracts are reviewed carefully. And if you're not really understanding some of the nuances of copyright law, bring in a lawyer to help out. It's better to do that. It's better to invest a little bit to have an IP lawyer review your contract rather than you have your client sign a contract that later can come back to bite them and consequently can come back to bite you. And then the other thing is registration of a copyright. Now, once we entered into the Berne Convention, we no longer had to, registration was not required, and it isn't required today. However, there are many, many, many benefits to copyright registration. Number one, there's just a good return on your investment. Even if you hire a lawyer to do it, if it's a valuable piece of work, believe me, it's going to have a return on investment for many, many years to come. And who knows, maybe way into the next generation, you'll be able to leave something to your heirs that's valuable, that's worth something for them. It establishes a public record. The other thing is you actually receive a nice little certificate of registration. Although I will say, back in the day, we used to have certificates that were on parchment paper, so they were really, really nice. Now they just send it on a regular piece of paper. But nonetheless, it's a certificate of registration. If you have a registered copyright, you can use it anywhere in the United States. Also, if you have a registered copyright, it becomes easier to secure a registration in any in another country. So let's suppose you do work not only, or your client is doing work not only here in the US, but let's say they're doing work in France, in Spain, in China, in the UK, then it would be easier for them to secure that international registration. If you have a copyright registration, it's also possible that you might be able to receive statutory damages, which could be a lot. You can potentially get punitive damages. You potentially can get trouble damages. You can receive attorney's fees. Again, possibly. And to me, one of the most important of all of these benefits is you get to sue for copyright infringement. Again, you don't have to have registration. However, if you're thinking that your work is very valuable and you want to potentially be able to sue down the road if someone infringes your work, you must have a registration. So again, there are two cases here. The first one I'll say was a really important case that came down in 2019. Before Fourth Estate Public Benefit Corporation case occurred, there was a battle between the circuits. So you had some circuits, like where I am in the Ninth Circuit here in California, they were saying that as long as you have an application, you're good to go. There are other circuits that said, no, you have to actually have a full-blown registration. And it was a battle back and forth, which was quite confusing for a lot of copyright owners. And so the Supreme Court in 2019 handed down the decision that now you must have a registration if you are going to sue for copyright infringement. That is really important because there have been cases, and in that Fourth Estate case was an example of the fact that the party had every right and they had strong legs to stand on in order to prevail in that copyright matter. But because they had no registration in place, they didn't prevail. So some of the things to be aware of that you might counsel your clients about, or even yourself: ignore the poor man's copyright. Okay, now, what is that? Well, I think it's the most ridiculous thing. The poor man's copyright is where, and I believe it must have been some poor young author or some poor artist that felt, as long as I mailed a copy of my work to myself, that's proof of ownership. Well, even the Copyright Office on its website, under the frequently asked questions section, says, no, do not buy into that. Poor man's copyright is useless. Why? Because if you have to have a registration in order to sue, mailing something to yourself doesn't really help you. So I would say don't even pay that one any mind. Eligibility for statutory damages and attorney's fees will occur, number one, if the work is registered before an infringement occurs. Before the infringement occurs, or if it's published already, it's registered within that first 90 days of publication. So here is something to also be aware of. Let's suppose there's an infringement that occurs and you and your client discover, oh my God, there's no registration in place. The Copyright Office permits what we call expedited registration, an expedited application. You can file, and the problem here is you have to pay a whole lot more money. I think now it's probably about $1,000. It was $900 and something before. You have to pay an awful lot of money if you wait and file an expedited application. That's why it's so much better to go ahead and file now, or as soon as your client creates this work, or as soon as they publish it, because the fees are a lot less. Even your fee is still going to probably be less if they have you do it, if they have any lawyer handle it. The fees are what, $45, $55, $65. But if you file an expedited application, it's going to be upward of $1,000. So being very mindful of that. The other thing is the Copyright Office, like the Trademark Office, discourages paper. You can file a paper application, but you're going to pay so much more because they want to discourage it. And it's the same with the Trademark Office. To file a trademark application, it's a lot less. I mean, it's still expensive, but it's going to be a whole lot more if you file with paper. If by chance you have a client that has a copyright claim or potential claim that's worth less than $30,000, it's best to have them go through the Copyright Claims Board. And that's really like a small claims court for copyright matters. And again, on the website, and you will have, when you have this, my materials, you'll be able to just click right on that image, but you can go to copyright.gov. And again, on the right-hand side, the same location where you'll find the compendium, you'll also find a link to the Copyright Claims Board. Okay, so a copyright owner, when they create their original work of art or authorship and reduce it to a tangible format, they automatically have a number of exclusive rights. Number one, they have the right to reproduce their work. So they can duplicate it. Let's suppose they write a book. And let's say they do it, they self-publish the book themselves. They can make as many copies of that book as they like because they're the copyright owner. Let's say you've got a client that takes great photographs. They have the right to display their copyright protected content. They can post it all over a website. Maybe if they have their own gallery, they can, display those beautiful photographs. They can display them anywhere. They can go to a community center if the community center will allow it and display their work. So the copyright owner has the right to reproduce, the right to display. They have the right to distribute their work. What does that mean? That means they can rent, license, sell. They can do anything they want with it. They have the right to distribute their work. Let's suppose that copyright owner creates, let's say they create a one-person show, a one-man show, a one-woman show. They have the right to perform their work. Let's say they write a song. And let's say they write the lyrics and the melody. They can go and perform their song anywhere. They can go on the street and perform it. That's one of the exclusive rights of a copyright owner. Let's say they decide they're going to write a book. And let's say the book is very, very successful here in the United States. And let's say there are people in other countries that would like to have that book translated in different languages. Okay, the copyright owner has the right to create derivative works or adaptations of their work. They can translate it in a ton of languages if they choose. But you know what else they can do in terms of derivative works? Let's say they write a book and there's a producer, a TV producer that comes to them and they love that book and they think it could be the basis of a TV movie. Okay, they can create that TV movie. They can do it themselves. They can do a video of it themselves. They can, they can do anything they want. They can create a coaching program around that book. They can do speaking around that book. They can create all kinds of derivative products based on that one book. But the other cool thing is they have the right to transfer their rights to someone else. So let's suppose your client writes a book, and let's say they enter into a publishing agreement with a traditional publisher. They're not self-publishing it. They're not going through a vanity press. Let's suppose they're going to one of the big guys. They're going to put in a random, let's say, big traditional publisher. Well, in order for that publishing house to take on that work, that book, they have to be able to reproduce the book. They have to be able to display it once it's done. They have to be able to distribute. In some cases, depending upon the author, they might also want to give the right to that traditional publisher to create derivative works. Now, sometimes when I'm representing authors, it's really going to depend on what my author is able to do. If I've got a client that is highly successful and they've got their own products and they're capable of creating more, I'm going to carve out the derivative works section of that publishing agreement. I'm going to retain that for my client. Likewise, the client might be able to, or they might want to perform their own work without giving that to the publisher. I might carve that out of the publishing agreement. So it's really going to depend, and each situation is different, but that's definitely something to think about. So if these are the rights that a copyright owner has, then these are also going to be the rights that can be infringed. So if there's someone who uses a copyright protected piece of content without permission, without having a license, or without that use falling within the fair use doctrine, then that's going to be considered copyright infringement. So fair use is a very gray area, and it's a very tricky area. And, oftentimes I'll have people call up and say, somebody is using my work. I want to sue. So first thing, when somebody says, I want to sue, I let them know how expensive lawsuits are, and I'm not footing the bill. They're going to have to pay for that litigation. All of a sudden, they're thinking twice about it. But I also want to make sure that what they think is infringement cannot necessarily fall within the fair use factors. So there are 4 items, 4 fair use factors that, quite honestly, up until a major case, and I've also included some of these case resources, but prior to Campbell v. Acuff-Rose, which came out in 94, all 4 of the fair use factors were being considered. What's the purpose and character of the use? So is that use being used for commercial purposes, or is it for educational purposes? When Acuff-Rose came out, all of a sudden the Supreme Court stopped necessarily looking at all 4 factors, and they looked at, in that first factor, they looked at something called transformativeness. And that's what a lot of courts only looked at until a more recent case that came out in 2023, which I also included the citation here for you, the Andy Warhol Foundation case. And so the 4 factors: purpose and character, character of use, the nature of the copyrighted work. So is it being used for commentary? Is it being used for news purposes? Is it a satire? Is it a parody? Is it being used for scholarship, for education? That comes out of the nature section, the nature factor. How much of it's being used? Is a lot of it being used? Is a little bit being used? And in this particular case, sometimes people think if they're only using a little bit, that it's okay. That if they're only using a little bit of the work, then it's considered fair use. Well, a number of years ago, there was a case that came down. It was, the issue was whether 60 seconds, 1 minute of a 90-minute documentary was considered fair use. Hear me? 60 seconds, 90 minutes, 1 minute, 90 minutes. The court came back and held that it was not a fair use. That even though only 1 minute of a 90-minute documentary was used, that 1 minute went to the core of what that entire 90 minutes was about. It went to the essence of the work. And so, again, looking at all four factors is so important. The fourth factor, what's the market impact on the original? So let's suppose you have a client that is a copyright owner. They write a book. The book is fabulous. The book is selling all over the place. Then let's suppose that someone comes along. They create a book that's almost identical. And they say because they've made some changes to it, they've transformed some of the pieces in there, they've made it a little more creative, that really speaks to the fact that it should be a fair use. But let's say that book, even the transformed document that they've created, it prevents the original from making money. It eats into the original copyright owner's ability to make money, because even though that new version might be different, it still impacts the original copyright owner's ability to make money on their own work. So now all four factors, really, I encourage you, if you're doing an analysis of fair use, don't just look at transformativeness. And again, because of the Andy Warhol case, now more and more courts are going back to looking at all four factors: purpose and character of the use, the nature of the use, how much is being used, and if the amount used goes to the essence of the work, and what's the impact on the copyright owner's ability to make money. Practice notes, again, don't assume that just because something's on the internet, it's free. I know that there are lots of people that think so. And even if you have a client that's using royalty-free material, read those terms of use, because even royalty-free has certain limitations, certain ways that you can use that work, and certain ways you are not permitted to use the work. If the client didn't create something, assume that someone else did. And I'm a big believer in just getting permission. I just think it's just an easier way to do it. So some landmines I'd like to throw out for you to just think about. Again, nowadays, most people, I'm sure there are some people who are not on social media, but most people are. And many people on social media are creating content. Be mindful of that, because oftentimes they're downloading content that already exists and they haven't asked permission to use it, whether it's incorporating music into their blog posts, whether it's mashing up, creating a mashup of someone else's material with their own. The other thing is AI-generated content. I know there's a wonderful new Justia webinar on AI. I encourage you to take a look at it. I actually reviewed it recently, and it was excellent. AI-generated content can sometimes be problematic, even for lawyers. So a number of years ago, when we started to see AI actually infiltrate everything, there was a lawyer, and now I know that there are several lawyers that have made this mistake. But the first one a few years ago, I recall, this lawyer created a brief. He was a litigator. He created a brief, and he had AI come up with, number one, AI created the brief, and AI came up with all of the citations. Every single cite was wrong. Every single cite. The court, you can only imagine how the court handled that. I mean, talk about lazy, because as lawyers, we have a responsibility to do our own due diligence. And if you're going to use AI, which it's great, you want to just double check everything. Every citation I have included in here, you best know that I have verified every single one of them. AI generated content is created by a computer, not humans. So make sure you verify, you do your own due diligence. Valuation of documents. Oftentimes, whether you're entering into a merger and acquisition, whether you are coming up in a licensing relationship, you're entering to a licensing relationship, or you are creating a settlement relationship with a client. You want to make sure that, number one, the client that says they own that content, you want to make sure they do. Again, that's the due diligence on your part. You want to check the chain of title. Make sure they own what they say they own. Make sure nothing's been assigned, even after they created that content. And then with regard to estate planning, so you can leave copyrighted content and you can transfer ownership of a copyright in a will or a trust. You are able to do that. The thing here to note is, in a will, if the copyright has been transferred in a will, that relationship cannot be terminated. Going back to recapture, termination and recapture. If it's in a will, it cannot be terminated. If it's in a trust, it can be. So what I do with clients when I'm drafting trust agreements, I make sure that their IP, their copyright in particular, is noted in the will. I may even put it in the trust as well, but I make sure that will has the transfer of those rights. Because again, keep in mind, the will does not allow someone years later, 35 years later, to come and terminate that relationship. And it might not matter to your client, but it might matter to one of their heirs. So I want to just go through a couple of these quickly. Do we have questions yet, Ina? Let me just check with you.
We do have a few, but feel free to go through the exercises.
Okay. So here's one. A small marketing firm hires a freelance graphic designer to create a logo for a client. The designer delivers the final files, but the written agreement does not explicitly state whether the work is a work for hire or whether the copyright has been assigned. 6 months later, the firm tries to license the logo to another client and the designer claims ownership. So, number one, that logo can't be protected by copyright. It's going to be protected by trademark, if at all. And even if it is, let's suppose it's a design and they happen to use it as a logo. Unless there is, number one, the marketing firm, again, the marketing firm, if the person who creates the work is an employee, the marketing firm is going to own that work. If it's an independent contractor and there is no work for hire agreement in place, no assignment agreement in place, the firm is not able to license that work. Why not? Because they don't own it. They don't own it. If, however, they have a work for hire agreement with that, also I would encourage them to have an assignment provision, then then they have the right to license it because then they own the work. Here's another one, a law blogger, could be any blogger. They quote several paragraphs from a published novel to illustrate a point about contract law in a CLE article. The blogger credits the author, but uses almost half of a chapter. The author's publisher sends a cease and desist letter. So, number one here, if the author's publisher, again, I'm assuming they've got a written agreement, and let's suppose it's a traditional publisher, absolutely, that publisher can send a cease and desist. Why? Because, well, presupposing that the portion of that published novel really goes to the core of what that book is all about. So I'm going to assume that it is, and because it's a novel, it's a creative work. So creative works, the courts look at more so as an infringement if someone uses that, as opposed to if it was a nonfiction work, because novels require more creativity. And then here, let's look at this last one. Let's say you've got two attorneys that collaborate on drafting a comprehensive practice guide. One attorney writes the bulk of the content, while the other provides just the commentary, examples, and edits. Later, one attorney wants to license the guide to a publisher without the other's consent. Again, if these two attorneys, not just that they're collaborating, but if they entered into this relationship, number one, with the intent of creating a joint work, and if their work is integral to the whole, which it appears that it is, then one of them could go ahead and enter into a relationship with the publisher and not tell the other. On the other hand, down the road, if there are any royalties to be had, the attorney that went to the publishing house, they have a responsibility to account to the other attorney, and they will probably have to pay some royalties. But they can go and do anything they want. They can license it. They can do anything they want with that work.
Awesome. Well, thank you so much, Francine, for breaking down all of those concepts for us. And thank you to Francine for setting aside a little bit of extra time for questions. So I'll just kind of run through what we have now, and then we'll wrap up. All right. Our first question is, can movie titles be protected in copyright as well, or is that trademark law?
Titles of any kind cannot be protected by copyright. If a title is going to be protected, it needs to be by trademark, and there are certain things that must occur in order for that to happen.
Thank you for clarifying. This next question is about the work for hire doctrine. So this person asks, what about a law professor writing an academic journal article? Does the law school or university own the work under the work for hire doctrine?
So it depends. And again, it always depends on contracts. So if the law school has entered into an agreement with the professor, which one would think they have, it depends on what that contract is going to say, which is why I stress over and over and over again, understand the agreement that you sign. Really. And lawyers are also notorious for not reading agreements. I mean, I cannot tell you how often when I'm doing a social media presentation and we're looking at terms of use, most lawyers in the room, when I ask how many have read the terms, very few of them have. So again, read those contracts. That's really what's going to determine.
Thank you, Francine. Our next question is, what do you think are the most common copyright misconceptions that non-IP lawyers have?
That everything on the internet is free. Honestly, I think that's like the biggest one. If it's on the internet, it's okay for me to use it. That's what people think. And that's just it. not only is it a misconception, to me, it's a landmine, because there are enough lawsuits against people who have used material that they've gotten from the internet. So, yeah.
Awesome. Thank you. We have time for 2 more questions. So this next one is, you said that if copyrights are in a will, they cannot be transferred. So if a father sets up a will for a child to get the copyright and then changes his mind, can he change the will without the transfer of copyright to a buyer?
I'm sorry, I'm not totally sure what he's saying, but you can transfer a copyright in a will and a trust. Yes, you can. So that's number one. You are able to do that. What I said was, subsequently, if you got a copyright, which you're talking about the rights in a will, down the road, if one of your heirs, let's say you leave it to an heir, and the heir down the road wants to terminate. Well, no, let's step back. Let's say you've transferred the rights to a third party. And in your will, you state that your child actually gets the rights, but they don't have the rights because you've already given it to someone else. So your child has the right to attempt. No, I'm getting myself confused. So let me really step back. If copyright that's transferred in a will can never be terminated by a third party, so a third party down the road can't come if they created the work and you have now left it in your will to your kid. That third party can't come along and try to terminate that relationship and take back the copyright. They can't do that. Your kid's going to have it, period. If it's in a trust, however, they would be able, a third party would be able to come and terminate that copyright ownership of your child if you left it in a trust. I'm not sure if that's coming out now. Put it in a will. That's the bottom line. And just, because if you've given it to someone else down the road, if you were a young author or you were a young musician, you sold your musical piece 35 years ago and you got money for it, but now you're dead, your child, who is the heir of your estate, if they decide they want to go and try to get your work back, they can only do it if it's in the trust.
Thank you so much for clarifying, Francine. Just to be respectful of your time, I think we'll go ahead and wrap up. So thank you so much again for your presentation and answering all of our audience questions. And thank you to everyone who submitted questions. If we weren't able to get to your question today, you can always reach out to us at support.justia.com and we can connect you with Francine in the interim.
I'd be happy to.
Wonderful. Thank you so much. So we want to thank you all so much for joining us for another Justia webinar. As I mentioned earlier, if you're a lawyer attending today, don't miss out on the Justia Lawyer Directory, a free tool to boost your professional presence. You can claim your profile at lawyers.justia.com to get in front of the eyes that matter. And if you want even more visibility, we have our Justia Premium placements, both gold and platinum, to get you ahead of the competition. And you can learn more about those at marketing.justia.com. Have a wonderful rest of your day. Thank you. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.